Okay, hello everyone. Thanks so much to everybody who's joining us for the second discussion in our series on race and the 1L curriculum. I'm Kate Evans. I direct the Immigrant Rights Clinic and teach immigration law and policy, as well as a readings course on race and immigration enforcement. I also advise the Duke Immigrant and Refugee Project, which provides pro bono opportunities for law students to advocate on behalf of immigrants and refugees. I hope to get to know many of you through these classes after your 1L year or through volunteering with DIRP. Though I do not teach criminal law, my research and my work in the clinic often involves challenging the immigration consequences of criminal convictions and the use of local criminal justice systems to enforce federal civil immigration law. Our clients regularly face racial discrimination in the criminal judicial system, which is then compounded by attaching immigration enforcement to local policing and jailing practices. In addition to working at the intersection of criminal and immigration law, I jumped at the chance to help facilitate today's panel because our speakers demonstrate one of the reasons I was so excited to join Duke Law last year. They are engaged in cutting-edge advocacy that builds on historic movements for civil rights and racial equity in North Carolina and are paving the way nationally as a result. In this past year, movements to address deep racial inequalities embedded in the criminal system have gained greater prominence and popular support. At the forefront of these movements are leaders in North Carolina fighting the cash bail system that incarcerates people based on poverty, the racially disparate disenfranchisement of individuals based on their criminal history, and the dangerous conditions facing largely Black and Brown people in local jails. Today, we will hear about the innovative racial justice work by these leaders here in Durham and across the state. As part of this series on race and the 1L curriculum, we wanted to showcase the incredible efforts to reform the criminal justice system that you can join as law students and soon as lawyers. We will begin with a roundtable discussion facilitated by Professor Brandon Garrett, followed by a question and answer period. Please feel free to submit your questions at any point in our discussion using the Q&A function at the bottom, and I'll collect them so that Professor Garrett and I can present them to our panelists at the end. First, let me introduce today's speakers. Professor Brandon Garrett joined the Duke Law faculty in 2018 as the inaugural L. Neil Williams Jr. Professor of Law. He founded and directs the Wilson Center for Science and Justice at Duke, which works on reforming the criminal legal system. We agreed that I would not try to summarize his litany of accomplishments so that we can spend as much time as possible with our guests. Needless to say, he has a litany of accomplishments. Daryl Atkinson is co-director of Forward Justice, a nonpartisan law, policy, and strategy center dedicated to advancing racial, social, and economic justice in the South. Forward Justice brings together organizers, lawyers, creatives, strategists, and directly impacted people dedicated to ensuring that the we the people is truly inclusive and representative of all Americans. Before joining Forward Justice, Mr. Atkinson was a senior staff attorney at the Southern Coalition for Social Justice, where he focused on removing the legal barriers triggered by contact with the criminal justice system. He also served as a staff attorney at the North Carolina Office of Indigent Defense Services, where he helped develop an online searchable database that allows the user to identify the collateral consequences triggered by North Carolina convictions. In 2014, Mr. Atkinson was recognized by the White House as a reentry and employment champion of change for his extraordinary work to facilitate employment opportunities for people with criminal records. Andrea Muffin Hudson is an activist, abolitionist, and freedom fighter who fights for people's rights in and out of the courtroom. Her own interaction with the criminal justice system led to incarceration, resulted in homelessness, restriction of employment opportunities, and access to support services. With two children, the intersectionality of these consequences, coupled with systemic racial discrimination, directed her to advocacy, where, while trying to find remedies for herself, she was able to become a leader in service to others. She is the director of Durham's Participatory Defense Hub, which has saved over 700 years of incarceration for people. She also leads the court mobbing effort, showing up to court in force in solidarity with Black and Brown people who are over-criminalized by our judicial system. Muffin is the director of the North Carolina Community Bail Fund of Durham. The North Carolina Bail Fund posts low-cost bail for people who could not otherwise afford it so that they can return to their homes, jobs, and communities, in turn giving them a more equitable proceeding in court. In 2018, Muffin was appointed to the Human Relations Commission in Durham. As an organizer, Muffin is a member of the National Council for Incarcerated and Formerly Incarcerated Women and Girls. She is also a member of All of Us or None North Carolina, which is a national grassroots civil and human rights organization fighting for the rights of formerly and currently incarcerated people and their families. The goal of All of Us or None is to strengthen the voices of people most affected by mass incarceration and the growth of the prison industrial complex in order to build a political movement to win full restoration of members' human and civil rights. Ms. Hudson has built a reputation for bold truth-telling, demanding the same level of accountability across the board, and bringing attention to the harms our current system imposes as a result of institutional racism. And finally, Leah Kang is a staff attorney with the ACLU of North Carolina, where she works on a range of civil rights and racial justice issues. We will hear more about her successes in challenging local practices that jail people for their inability to pay in a moment. Prior to joining the ACLU of North Carolina in 2019, Leah was a staff attorney at Forward Justice, where her work focused on voting rights. She also spent 2 years at Advancement Project in Washington, D.C., where she provided community lawyering support for grassroots and youth-led organizations across the country in their campaigns for education justice. Leah clerked on the U.S. Court of Appeals for the First Circuit and the U.S. District Court for the District of Maryland. Before law school, Leah taught 5th grade in a New York City public school in the Bronx for 3 years, an experience she describes as an immense privilege. Thank you so much to our panelists for taking the time to share your work with us today. And with that, I'll hand it over to Professor Brandon Garrett to kick off the discussion.
Thank you all again. It is such a pleasure to have you here, and we can't wait to bring you back when we can meet in person someday. And my main thought was that each of you would talk about some of the truly powerful work that you're doing here in the Triangle, here in North Carolina, so that our students taking criminal law can see what it means to do powerful work designed to change our criminal legal system. Thought we'd go in alphabetical order, starting with Daryl and then Muffin and then Leah. And the idea is to introduce students to your work. And I know, Daryl, you have a demonstrative to show us. And so from a really important recent case. So we'll start with you and look forward to hearing about your work and watch the demonstrative. And then we'll turn to Muffin and to Leah.
Can folks hear me? Because I am experiencing some technical difficulties.
I think Daryl might be frozen, Brandon.
Yeah. Ah, you're back. Oh, and now froze. I think now you're frozen again. Well, maybe what we should do is see what happens with your connection, and I hope it comes back. What's causing the freezing is the demonstrative. Maybe we could just, you could start by talking about the case without using that. Or we could just give your internet a little bit of time and have Muffin kick us off.
Yeah, can you hear me, Brandon?
Yes.
I'm having some technical difficulties. I guess it's representative of the age that we're in. As soon as it's time to, be with you all, I get all kind of internet problems. So it is what it is. Maybe I can either do this orally or we can try to go in a different order. But either way, our theory of change at Forward Justice is, we have 3 animating theories of change when we think about our work. One, change the South, change the nation. DuBose was prophetic. You win the South, you win the country. Movements, some of our most potent social movements have been birthed in the South. Take, for example, radical Reconstruction, civil rights movement. And then movements are led at their moral center by the people who are most directly impacted by those movements, right? They have to be the ones who are at the forefront because they have skin in the game. If you look at the most recent transitions in our leadership in this country, whether you're looking at RBG or John Lewis or what have you, you know, those people were impacted by the things that they were fighting against, which gave them, you know, extra motivation and animation to try to get those particular injustices changed. And so we believe that that has to be at the forefront. In thinking about our Unlock the Vote campaign and our attempts to enlarge the we and we the people, our biggest fights in this country have been about who's included in that we. At one point, African Americans weren't included, women weren't included. And so, you know, we are fighting to make sure that people with contact, who've had contact with the criminal legal system, are included in that we. And we're doing that using our 3 principal strategies by changing law, policy, and practice in a way that builds power for our people. And that's where our litigation comes in and Community Success Initiative versus More, but also through communications and changing the way that we talk about these issues, because we believe narrative power is equally as important as legal changes. And so we've had a series of billboards and PSAs and radio all around trying to change the narrative around people with records and their ability to be able to cast a ballot and be able to participate in our society. And then lastly, we have to build a broad-based movement to be able to make these changes sustainable, real, and durable. And so, you know, we are doing everything we can to contact low propensity, directly impacted voters to let them know about their voting status and encourage them to get registered to vote to enlarge that week. So CSI versus More, it was a case that we brought challenging the constitutionality of North Carolina General Statute 13-1, the disenfranchisement statute. And we brought 5 principal claims, constitutional claims under the North Carolina state constitution. This was not a federal case. This was a state constitutional case. And that is purposeful. Our, you know, if you want to call him a president, has appointed over 200 federal judges and may appoint the 3rd Supreme Court judges. Federal court for the next generation is going to be tough sledding. And so we intentionally focused on state constitutional claims. And one being 13-1 was in violation of our free election clause claim. That's Section 1, Article 1, Section 10 of the North Carolina Constitution. In addition, we made claims that it violated the Equal Protection Clause in Article 1, Section 19 under both race-based and wealth-based discrimination claims, as well as that it violated North Carolina's Article 1, Section 11 ban on property qualifications. And you know, those claims were successful on 2 of them anyway. We won in front of a 3-judge panel on 2 of our claims, the wealth-based equal protection discrimination claim, as well as the ban on property qualifications, that we were successful on as well. We have to go to trial on the free elections clause claim and the race-based equal protection claim. But in doing that work, we established such a significant record of unrebutted facts. And this is important for the law students to understand, because the legal standard of summary judgment is appropriate when there's no genuine issue of material fact at issue, and the movement is entitled to judgment as a matter of law. So once you go through all the briefing, all the discovery, and you've established these are the facts in the record that have not been rebutted by the opposing side, they are indeed fact that then the jurists can use to apply law to come with their requisite decision. The other legal standard that we had to grapple with was the preliminary injunction standard, where plaintiffs have to show a likelihood of success, as well as on their claims, as well as irreparable harm, that they will suffer irreparable harm if the injunction is not issued, as well as a balance of the equities. And as far as evidence that we were able to put in the record related to race, related to class-based discrimination, it was significant. Every everything from the racist origins of the felony disenfranchisement law. So for example, felony disenfranchisement in North Carolina did not exist prior to 1877. That's right on the heels of radical Reconstruction. It was put into the North Carolina Constitution to dilute political power of Black men and the fusion politics that was happening with Black folks and poor white folks in North Carolina. And this is significant because during that radical Reconstruction period, we had the ban on property qualifications. We had the right to vote given to Black males. We can talk about the patriarchy embedded in that women didn't get the vote until after that. But we had these changes, radical changes during that Reconstruction period that felony disenfranchisement was directly targeted towards. And we were able to show that the legal scheme that was put in place in 1877 largely remains in place today. One, it applied to all felonies, not just infamous crimes. Previously in North Carolina's history, you were only disenfranchised if you were convicted of an infamous crime or whipped into infamy. Number two, it premised that disenfranchisement for a certain period of time, and at that period it took about 4 years to get your rights back. The average term of probation in North Carolina, you don't get your rights back until you complete all terms of probation and parole, which is what we were trying to knock down so people in the community could be able to vote. And you don't get that term, you don't get your voting rights back until you get what's called an unconditional discharge. And fulfilling probation, the average term is about 30 months in North Carolina. And then third, just as in the late 1877s, it's a crime to vote while you're on probation. It's still a crime to vote while you're on probation. And in 2016, 16 folks, 12 folks known as the Alamance 12 were targeted and convicted or prosecuted because of voting while on probation. So that statutory scheme is largely the same. As far as the other, we were successful in having a significant Amici record, and Amici, the Sentencing Project, put in significant data showing that African Americans are treated differently at every stage of the criminal legal system, from stops to arrests to who's searched to who's prosecuted to prosecutors using their peremptory strikes disproportionately against Black jurors to sentencing to at every single point on the criminal legal continuum. We were able to put in the record that African Americans are treated significantly different as a result of this cumulative disparate disproportionality that we see along the criminal justice continuum. It's no secret that African Americans are disproportionately impacted by felony disenfranchisement. So for example, 21% of the voting age population is African American, 42% of the people disenfranchised in North Carolina are African American, which divest those communities of substantial equal voting power. 84 of 100 counties in this state, 25% of the counties, in fact, 84 of 100 counties, the disenfranchisement rate for Blacks is higher than whites. In 25% of our state, that disenfranchisement rate is 4 times the rate for Blacks and whites. And some of our so-called liberal bastions, for example, Mecklenburg County, the disenfranchisement rate is 7 times the rate for Blacks and whites. Buncombe County is 8 times the rate. Wake County is 6 times the rate. And in Orange County, where our, one of our flagship universities is, the disenfranchisement rate is 8 times the rate. African American men represent 9% of the voting age population. They represent 36% of the people who are disenfranchised, largely muting the gains of the 15th Amendment and the 1965 Voting Rights Act. And it was in this context that we made some of our race-based discrimination claims. But the evidence was equally significant on the wealth-based discrimination, because in North Carolina, the way that we have set up your ability to receive an unconditional discharge, which unlocks your rights restoration. Remember, you do not complete probation or parole in North Carolina until you completed all conditions of your sentence, including the payment of legal financial obligations to get the unconditional discharge. That essentially means you need to own a certain amount of money or a certain amount of property, right, to be able to get that unconditional discharge. And that's wealth-based discrimination under the Equal Protection Clause, and it also violates the ban on property qualifications under the North Carolina Constitution, and we were able to get the court to agree with us on both counts. I'll pause there. It may be some more stuff to come out on Q&A, but you know, I hate that the tech is bad, Brandon. I wanted to be able to share some of those visuals, but you know, we'll try another day.
Thank you so much. And we don't need tech. This is great. I really appreciate it. And let's turn to you, Muffin, and tell us a little bit more about yourself and the work that you've been doing here in our courts in Durham.
Okay. So my name's Andrea, everybody calls me Muffin. When I was incarcerated back in 2013, I sat in jail for 51 days, I think. And my bond was originally $10,000, but the judge was like, my bond wasn't high enough when I went for my first appearance. So he raised it to 30,000. And I sat in jail for months. And I finally, you know, told my attorney, you know, I'll go ahead and plead guilty. Even though I know I wasn't guilty, I was like, I'll plead guilty because I want to go home. And so after sitting for months, then the DA was like, well, she said she'll plead guilty to anything. So if she pleads guilty to this one, we'll dismiss all of the charges. And so I was able to go home. But when I went home, I didn't realize that the victim had said, you know, that it wasn't me, you know, and so the DA still got me to plead guilty to something I didn't do simply because he knew that I didn't want to stay incarcerated. And so I lost my housing because at that time I was on Section 8, and I missed my appointment, and my daughter was only 17, so she wasn't old enough to legally enter into a contract. So even though she was on my lease, you know, we had to move. I lost my job, and I couldn't find a job because I was doing private duty. And anytime you do private duty, it's a nurse, and so you can't be in someone's home taking care of them if you have these charges. Even though they were dismissed, they still were showing up. And so I saw a young man on Facebook talking about a clean slate clinic, and his name is Umar Muhammad, and he's no longer with us, but I went to this clean slate clinic, and that's where I met Umar, that's where I met Daryl, and I thought it was a scam because I was like, I'm from New York, so yeah, I was like, maybe I do have a warrant and they're gonna arrest everybody, but you know, that didn't happen, so I was glad. And then I was like, I'm gonna get a bill in the mail saying that I have to pay this money because I was able to talk to an attorney. That didn't happen. I got my expungement papers in the mail. And so once I got my expungement papers in the mail, I reached out to Umar and I was like, hey, I want to be a part of this organization, which was All of Us or None. And I was like, I want to be a part of this organization because I want to be able to give back, because the fact that it helped me, I want to be able to help someone else. And so that's how it started. And then how the bail fund started was one day, Dave Hall, he's Judge Hall now, he was the attorney at SCSJ, and he was like, hey, Muffin, you know, let's go to lunch today. And I was like, okay. So I went to lunch with Dave Hall, Henry Baird, and Jason Rice. And it was actually an interview for the bail fund per se, because these two young Duke graduates wanted to do something around ending money bail because they heard a podcast, but they knew that they didn't have the capabilities to be able to do it. So that's how it started, because I had been in the process, I've been through the process, it was a whole lot easier for me to be able to navigate through the system because I had actually been in the system. So I knew exactly what people needed on the other side. So I try to be who I wanted to come rescue me when I was sitting in jail. You know, along with the participatory defense, the food co-op to make sure people have food and clothes and things like that, because I understand that it's a full circle. It's not just a part of a circle. So when we bail folks out, we don't just bail them out and leave them. We offer them resources for housing. We offer them resources for clothes. We offer them resources for food. We offer them resources if they want to go back to school. So they have everything that they could possibly need if they want it. It's there. They just have to be willing to accept it. And we do the court mobbing because I noticed sitting in court that people who generally went to court by themselves ended up in handcuffs, and people who came to court with other people ended up walking out the door. And I was like, okay, so that's the difference. This person is standing there by themselves and they have no one there to advocate for them. And then folks had, the way I looked at it was like the judge was like, okay, if you don't have anybody that loves you enough to come and stand up in court with you, why should I care whether you go to jail or not? And so that's what we do with court mobbing. We make sure that the judge and the DACs, that we love our community, we love our people, and you're gonna have to be held accountable to what you do to our people. So if you mistreat them, then we know those are elected officials, and we make sure that we advocate for your replacement. That's how we were able to get the judge who raised my bond replaced. You know, I worked on a campaign of the judge that replaced him. So that's what we do. The bail fund bails out folks whose bond is $2,000 or less. Everything after George Floyd, we had this big influx of money that came in. So I was able to take $100,000 to the county jail, and I was able to bail out 27 people. And at that time, we did 10,000 or less because there wasn't enough folks in there who bond was under 2,000 to be able to bail them out. And I was like, well, since we have all this money, let's just raise it and get everyone out. You know, we really don't care what the charges are because they're only been accused of the charges. They haven't been convicted. So if they have a bond, then that means that they're bonds don't mean that people are dangerous. It just means whether or not they have money or not, right? So if they don't have money, they sit. If they have money, they're free to go home. It's not a public safety issue. It's a matter of whether or not someone has money. And we know the people who generally don't have the money are poor Black and brown folks. And so that's what we advocate for on a daily basis, is to make sure that we get folks who have low-level crimes, are accused of low-level crimes, are able to come home, because what happens is they're the ones that lose the most. Because if they sit in jail for 24 hours or 24 days, they can lose so much. They can lose their housing, they can lose their jobs, they can even lose their children. And so we try to make sure that we eliminate those barriers so people can get back to fighting their cases, because it's easier to fight your case from the outside than it is from the inside. Because on the inside, you have access to no one. And right now, in the midst of COVID, they're on 23 and 20, which means they're locked back for 23 hours a day, and they're only out for 20 minutes a day, 3 days a week. So that's very, very problematic because they still have COVID in the jail. So they have to be getting it from the staff or from folks that they're continuing to arrest. Because if you keep arresting people, you don't know who has COVID. So stop arresting people, give folks citations, and let them come to court and build, you know, then deal with them if they don't come to court.
Great, thank you so much. And by the way, everyone who's listening to this, please start sending in some questions so that we start to see your questions on the Q&A. We really look forward to hearing what your thoughts are, what your reactions are to the work that these amazing guests are doing. And last but not least, let's hear from Yulia about your work with the North Carolina ACLU. And if you'd like to talk a little bit about how you came to this work. Kate gave a wonderful introduction for all three of you, but if you want to say a little bit more about how you got into this work, just like Daryl did, talking about the mission of Forward Justice, and Muffin did, talking about how she came to create the bail fund, that would be great.
Sure. I will pick up a little bit where Muffin left off. I think Muffin just gave everybody an excellent 101 on the broader push to eliminate unjust cash bail. And the incredible efforts that, you know, Muffin as a community leader and the North Carolina Community Bail Fund have made, and that others in this space, in this state have made to really change the reality of what the use of unjust cash bail looks like in North Carolina. And I'll pick up where Muffin left off with just a short story of a client who is the lead plaintiff in our case, Allison V. Allen. The ACLU is litigating this with co-counsel from Civil Rights Corps and the National ACLU office. It's a federal class action lawsuit that was filed late in 2019, challenging the cash bail practices in Alamance County. And Mr. Antonio Harrell, who is a lead plaintiff in our case, we met Mr. Harrell when he was sitting in jail, as Muffin described. Oh my goodness, I'm so sorry. This is a COVID event. I'm working from home and somebody is at the door currently. I'm so sorry let me just see if I can get them to go away. Brandon, I'm sorry. I don't know if it makes sense to go to somebody else for just one moment.
I can pick up for a minute while you're going to the door and say some things about the case. While Leah's going to the door, and you know, this is how life is. It's okay.
Hi, I'm sorry. Can you just load it?
There we go. So no one has in recent years brought a constitutional challenge to cash bail systems in North Carolina. So this case in Alamance that we was just starting to talk about, really big deal. All eyes are watching this case. The prior bail system in Alamance looks a lot like every other county in North Carolina where there's a cash bail schedule. And so what does the magistrate do? They look at the schedule. What are you charged with? $10,000, $5,000. And so, well, now Leo's back, but
Sorry about that.
I'm just starting to say, like, what a big deal it was to have a constitutional challenge to one of the local bail systems in North Carolina. And
That's right.
I wasn't going to say whether Alamance was worse or better, but in a lot of ways, every county has some version, or until recently had some version of a bail schedule with not too many exceptions in this state.
That's right. And here's what I'll tell you for Mr. Harrell. He was arrested for trespassing and shoplifting, and saw a magistrate judge who set a bond at $1,500, which Mr. Harrell could not afford to pay. And then gave him a piece of paper that said his next court date was almost a month from that date of his arrest. And as Muffin pointed out, if Mr. Harrell had had that money, he would have been home and he would have been able to pick up his life, go back to work the next day, not fear about losing his housing. But because he didn't have that money, his choice was to sit in jail until the next court date, which, as I said, the piece of paper he was given said would be 3 to 4 weeks from the time that he had been arrested. What I want to point out here, and I think Muffin touched on this is not a public safety issue. If we truly believe Mr. Harrell was such a threat to public safety that we needed to jail him, there would be another host of findings that magistrate should have made. But what the magistrate did and said was, within a minute or two, there was almost no conversation had, no inquiry as to what was going on for Mr. Harrell, what he could afford. Within a moment or two, chose a number that is arbitrary and attached to the crimes that he was charged with. And based on that, if he had no choice but to either sit in jail or somehow scrape together, make calls which are difficult from jail to try and post this bond. And what's important here is, you know, as students may know, there is not a shred of social science research. All of the research that has been done on the cash bail system says charging somebody money for their freedom does nothing to protect so-called community safety concerns, does nothing to ensure that a person will return to court, and has so little effect that it really becomes a situation where we are maintaining a system of criminalizing poverty, of jailing people because they are too poor to pay an arbitrary amount that a magistrate or a district judge sets in their case. And the fact of the matter is that our federal constitution prohibits this. Some of the students may know, I know you're one else, there's a line of cases, a United States Supreme Court case that followed Bearden v. Georgia and a bunch of cases following, that basically says our Equal Protection Clause and our Due Process Clause in our constitutions prohibit punishing people just because they're poor. And just think about how much sense that makes, right? Of course, it is against our equal protection and due process and fundamental fairness to punish people for no other reason than that they are too poor. And yet, that is exactly what was happening in Alamance County with the bail system. That is exactly what happened to Muffin on specious charges that, you know, clearly were later found to have no foundation. And running a bail system this way, where you are plucking numbers out of a sky or a bond table and imposing them on people who get arrested and charged and brought before magistrates and jail officials, detaining them on the basis that they can't afford that bond is just is a criminal legal system that none of us should be willing to stand for. So we filed suit, as I said, in federal court. We brought a couple different claims, most of which arise from equal protection and due process cases in the federal constitution. And we moved the court for emergency relief. And so as one else, you will learn a temporary restraining order is like an emergency, and a preliminary injunction is an emergency. And we filed both those things and asked the court, this really needs to stop. We've got clients, including Mr. Harrell, who are sitting in jail for no other reason that they're too poor to pay. That is not what the Constitution allows. And we're going to ask, you know, that this federal court intervene and make sure that if Alamance County is going to continue to have a pretrial release and bail system, that they do so in a way that is aligned with the federal Constitution. Almost as soon as we filed, the defendants, we sued the judges who imposed bail, the magistrates that imposed bail, and the sheriff who runs the jail in Alamance County came to the table and said, you know, let's talk about how we can fix this. And several months later, we had what is a consent preliminary injunction, meaning the defendants agreed to make drastic reforms to the way that they would engage in their pretrial release practices in Alamance County. And that consent preliminary injunction went into effect in July. In the months that have followed, things have been very different in Alamance County. So I'll just give you some examples. For both Muffin and Mr. Harrell, they had a bond set by a magistrate without counsel present and without a real conversation with them about what's affordable. And yet both people were charged but not proven guilty. These are presumptively innocent people. In our system of criminal law, you shouldn't be punished unless the state has actually met its burden to prove your guilt. So these presumptively indigent people were coming before magistrates and having a bond set without counsel, without an actual inquiry with the magistrate, and then were sitting in jail until their next court date. Under the terms of the consent preliminary injunction, we now have magistrates in Alamance County are required to have a conversation with the defendants who are before them, the people who are arrested before them, and make an inquiry as to their ability to pay. They should not be imposing a bond on somebody that person cannot pay, unless they are going to go through a constitutional process of making findings based on clear and convincing evidence that they are setting an unaffordable bond for the purpose of detaining somebody because they have clear and convincing evidence and reason to state that the person may pose a danger or may destroy evidence or may not appear in court. And then the same, that person will then, in Alamance County, under the terms of the consent preliminary injunction, get a full hearing where that person will have an attorney appointed from the Indigent Defense Services before a district judge, and that attorney will be available within 48 hours at that hearing to make arguments again before the judge about why bond should be an amount that the person can pay, or why that person should not be detained on an amount that they can't pay because there is some concern about dangerousness or failure that the person will not appear for court, or there will be the possibility of the destruction of evidence. Now, I just want to reiterate, under the new terms of the consent preliminary injunction, a judge can only set a bond amount that a person cannot afford if the judge first finds based on clear and convincing evidence that a person poses a danger, that a person may not appear, there's a likelihood they will not appear for their next court date, or there is a possibility that it will result in destruction of evidence. But and those three sort of state interests, those three state interests are actually enumerated in our state statutes that allow for bail. But I want to say again, even those three reasons, safety, appearance, or destruction of evidence, even those three, there is actually no research that suggests charging money for a person to be able to go home and sit at home along with the rest of the people who can afford that amount of money, that charging money will actually result in safety or result in a person's appearance in court. So it's some of the limits, I guess is what I'm trying to say, of what even though the consent preliminary injunction has made things very different in Alamance County, we still run up against the limits, I think, of having cash bail as a system at all that we use. And I'll just say, I think Daryl pointed out very much litigation, and this litigation in particular is usually only one tactic in a broad fight to end, unjust practices where they exist. And it could not be more true here. This particular case is just one strategy in one county that we hope obviously will have broader effects. But it comes alongside a really deep bench in this state of people who have been fighting the system of unjust cash bail in many places on the individual level. Muffin is, at that Durham courthouse or other courthouses, freeing people on a regular basis, pointing out the injustice of cash bail as a system, and pointing out how pretrial release, making sure presumptively innocent people are able to go about their lives until the state meets their burden of proving somebody guilty, that is a reality that judges and magistrates abide by. There are also efforts being taken by community groups all over, either through local community bail funds, court watching programs, many of whom Muffin has trained. Christy Puckett-Williams, who's the Campaign for Smart Justice campaign manager at our office, ACLU, have trained, are in the courthouses every day putting eyes on local judges and letting them know we're here and watching what is happening in this courthouse. That there have been efforts, obviously, on a policy level and advocacy level, and the hope is that one day we will look back at a pretrial release system that looks dramatically different than how it currently looks. And this litigation is definitely an important, but only one small part of that broader fight.
Great, thank you so much. Yeah, we've heard about efforts to use the courts to push access to voting, which could mean political power. We've talked about political efforts, including campaigns for local judges and activism, the bail fund, litigation challenging bail. So we've heard about a lot of different strategies that lawyers, non-lawyers, activists, people running for office can use to challenge some serious long-standing injustices. We have a couple of great questions already, and I wanted to pass those over to these incredible guests. But please keep posting questions. We'll definitely have time for quite a few questions. I have plenty of my own, but I see some more coming already. This is great. One question that just came in is, okay, so let's say there's victory at last, finally victory at last, and the cash bail systems that have been in place in North Carolina, just like in so many other states, finally come to an end. one of our students asks, well, what's the alternative to a cash bail system? What does that system look like? Is it no bail, bail in some other form? What do we replace cash bail with? I think those are, I think we'll all have comments on that question.
I'll go first. The alternatives of what I vision with a cash free bail system is if someone is being accused of a crime, then they're presumed innocent until proven guilty. That, I mean, that's what it say, but of course we know that's not what it is. But if that's what it actually is, if they're innocent until proven guilty, they should not have to pay anything until either the state proves that they are guilty and they are imposed some sort of fine or whatever the case may be. But they should just be given a citation to show up in court, because for the most part, people will show up in court. We have to find out why they don't show up in court, right? And if you meet the needs of the people, you'll have less crime anyway. If people had real affordable housing, if they had food and clothing, and they had a job not only to a livable wage, but a wage where they can thrive off of, you would have less crime. Because crime is committed out of a lack of something, whether it's a lack of food, a lack of money, a lack of clothes, a lack of housing, a lack of mental health care, right? People don't wake up and just say, I'm gonna commit a crime today. People wake up and say, I'm gonna survive today. And they're gonna survive by any means necessary. And that's why we have crime. So if everybody had everything they need, we wouldn't need a cash bail system. But we have a good statute right now to end cash bail today if we actually followed the statute that is in the state of North Carolina.
I think Muffin answered that perfectly, which is the question is, what are the alternatives to the criminal legal system as it currently exists altogether, right? Which is just exactly as Muffin said. Crime, why are we arresting people at all for what are many times crimes of poverty, crimes of need? As a more interim matter, I think that there are some jurisdictions that don't have cash bail at all. And that includes the federal. In the federal criminal system, you either have a outright detention order where you've had a full hearing, both sides have had to make vigorous arguments about why somebody should, be detained, and a judge has to write that out. And this is not well, let me see if this number ends up detaining you, and let me set a cash bail amount in your case. So there are, alternatives to cash bail as it exists, but I think that, what Muffin just described is exactly right, which is, let's all think about what are the alternatives to a criminal legal and punishment system altogether that results in breaking communities apart, that doesn't actually result in safety for any of us, and that is so racially disproportionately punitive to communities of color that it is, its legitimacy is under question.
Yeah, I guess the only thing that I would add from a sense of scale, I was a commissioner with the Office of Indigent Defense Services, and we did a reclassification study way back in, I think it was 2011. Jessie Smith has updated this kind of data most recently with some of her work. We got anywhere between 1.9 million unique case types that come into our court system every year. 85% of that is misdemeanor and traffic. When you factor in the bottom 3 felony classes, which are obtaining property by false pretenses, things that are nonviolent, non-sexual, non-threatening, when you factor in those bottom 3 felony classes, you're up to about 95, 96% of the case types, right? So let's just throw all of that out right there, right? Let's throw all of that stuff out. You don't need no cash bond for none of that junk. And in fact, it should be handled in a completely separate way outside of our criminal legal system. Because as folks said, we are criminalizing poverty, we're criminalizing our failure to invest in the community as far as mental health services. When you look at interactions between law enforcement and police, there are so many folks who are having active mental health episodes. But because we have chosen to let the criminal legal system be the catch basin for all of our social safety net failures on any given day around this mental health issue, the biggest mental health provider on any given day is LA County, Cook County, or Rikers Island, right? It just alternates on what population looks in jail for that particular day. So I would just submit that there's a lot of so-called offenses, if we want to call them that we should just scrap and completely decriminalize and deal with a completely different way. And then we ain't got all these worries about who we're going to give bond to and who we're not going to give bond to as far as cash.
Great. Yeah, here in Durham, there's like 7,000 to 10,000 misdemeanor arrests a year, and you don't need to use the community bail bond because those individuals are never held on bond. But then again, they go before a magistrate. Like, why? Why book those people, put them in front of magistration when we know they're going to be released? There isn't a situation here in Durham like in Alamance where you had people on misdemeanors ending up in the jail. But post-COVID, why not cite and release? But then, like Daryl asks, why even cite for many of those offenses? What good are they serving in the community? That's a much bigger question than your question about alternatives to the cash bail system, right? It's a question about alternatives to the whole system. So a more specific question we have, and please keep sending questions. A student asks about how you decide how to prioritize the use of the bail fund. So I'm guessing this one's for you, Muffin. And she writes that bail funds are really popular in Florida, but they've mostly been targeted towards protesters during especially the racial justice protests post-Floyd this summer. Bail funds have sprung up all around the country. You talked about this some, about what dollar amounts, what types of cases you take. Do you want to talk more about how you decide when and where to use the fund?
Okay, so every morning I get an alpha list of everyone that's currently being held in the Durham County Jail who bond is $2,000 or less. I go pre-COVID, I would go to first appearance court and see the folks who got arrested the night before, whether or not they made bond, or if their bonds were unsecured, or whatever the case may have been. The only thing I prioritize more is women, right? But I try to get women first, but I get anyone out as long as their bond is $2,000 or less, and we have the funds available in the bail fund. I can bail them out. There was a time where we didn't have money in the bail fund to be able to bail out, so many folks. I think in like 2019, I was only actually able to bail out maybe 10 people for the whole year because the funds weren't available. Because what happens is when we pay the bond, we pay the whole bond, we have to wait until the court case gets resolved in order to get that money back. Sometimes it can take up to a year for a court case to be resolved and then to be able to get the money back. A lot of time we didn't get the money back because after waiting for so long, a lot of the folks we bailed out were homeless folks. So if you're trying to figure out where you're going to live, the last thing you're going to do is remember a court date. And they would show up to their first court date, but when it gets to that 5th court date, they're not coming. And so that's the only hang up when it comes to the bail fund, is if the money's not available, we don't have the money to bail folks out. But we bail out anyone $2,000 or less. It doesn't matter what the charges are, as long as they have a bond that we can pay, we'll pay it.
So a question that's more for you, Leah, and Daryl. Question is, talk a little bit more about pros and cons of picking where you're going to bring your case, with the Moore case in state court under the North Carolina Constitution, like you were telling us, Daryl, and then the Allison case in federal court with federal equal protection, substantive due process claims. The kind of the strategy that goes into picking which claims, which court for cases like these.
Where you think you can win? I mean, I don't mean to be super facetious about that, right? But seriously, where you think you can win? I mean, for us, with voting and equal protection, the North Carolina state constitution is more expansive than the federal constitution in the way that it protects voting rights. So it made a lot of sense from that perspective. Our composition of our state court right now, you know what I mean, and how it's leaning, it made a lot of sense to go that route. Yeah, and we're finding, and this was one of the things that was really, really cool about the ban on property qualifications claim. The precedent that I was relying on was from the 1870s. I would assert that our state constitution is an underutilized vehicle to be able to access relief for our people, right? And we need to start pushing some of these constitutional provisions because it reads beautifully, right? We need to start pushing some of these constitutional provisions on what and demanding the court to interpret what they really mean, because people have not been doing that. And so it made another, the stars kind of aligned on those three for us, and that's why we brought it in state court.
Yeah, I think I would just add, I think there's increasing concern about the federal litigation route for many reasons, including what is sort of professed hostility to individual rights under the federal constitution by many jurists, and what the composition of the Supreme Court will look like, possibly if there's an appointment in the next 2 months or next couple weeks. And I think that what Daryl said was really smart, which is just that, part of what it is, we have a state constitution that is waiting to be developed more, right? There is so much there that will honestly be cases of first impression. And it needs to be a field that is carefully planted and called to be protective of individual people and their rights, which is how the state constitution was intended. I'll just give one other example. So Daryl and I are co-litigating a case in state court right now with several other partner organizations on behalf of the North Carolina NAACP and other clients, challenging the constitutionality of the conditions of confinement in the North Carolina state prisons as unconstitutional in light of this pandemic under the state constitution's prohibition against cruel or unusual punishment. And we're seeing the same thing where it is an underdeveloped area of law, but the postmarks, the benchmarks, the language from previous precedent from the North Carolina Supreme Court saying, this is a constitution that values human life. This is a constitution that that prioritizes the rights of people. They're all there to be able to really to push for better rulings that really do further the Constitution, both in language and purpose as it was written when it was, enacted in the Reconstruction.
I was actually just going to ask, I was hoping that all three of you could talk about the unique threat that COVID has posed in our jails and prisons here in North Carolina, and what challenges that creates to try to do racial justice work, criminal legal reform work. There have been new cases that have been brought, including the one that I'd love to hear more about that you just described, but also new challenges for advocates, some new opportunities. I'd love for you to talk about how this work has become really urgent since March, since COVID cases started to erupt and in these detention facilities scattered all around North Carolina.
It's been hard on the bail fund as far as being able to advocate for folks. At first appearance, we're no longer allowed in the courtrooms, even when they go to court. I have to tell the bailiff, we're out here, but they won't let us in, even though the sign on the door says, you can have up to 16 people. The judges aren't letting anyone in unless you have a case. And then, bailing folks out now, knowing that there are positive cases in the Durham County Jail is very hard because I have volunteers who volunteer their vehicles, you know, to provide transportation and things like that. And you really can't ask someone to volunteer to put their life in jeopardy for COVID because the Sheriff's Department and Health Department are not, you know, at liberty to say who has tested positive and who hasn't tested positive. So there's always that risk. So my volunteers don't want to, you know, they don't want to put someone in their car and they just don't know. So that's making it hard to be able to provide the transportation that we know folks need when they get out. We do provide them with masks, but that's about the extent of what we can do at this particular moment in time. The food co-op, you know, we have it every 2 weeks now, and it's like a rolling co-op. They can't come in and do the shopping on their own like they used to be able to do. Now they have to have pre-made bags and we have to hand them off to folks. So you don't have that connection of being able to walk around the co-op and have a conversation with folks to find out what more they may need other than just food. And we've been advocating for people to be released because we know that everyone most of the people in Durham County Jail are being held on pretrial detention, which means 1, they haven't been convicted of a crime. 2, even if they have been convicted of a crime, the crime does not warrant a death sentence. And that's always a possibility because they're in a confined space where they're not able to get the proper cleaning supplies to make sure that they can keep their areas sanitized. They don't get the proper personal protection equipment. You know, they get 1 mask. You know, unfortunately, you know, I got arrested in July, you know, and they gave me 1 mask and they was like, you have to wear this mask 24 hours a day. I'm like, but it's 1 mask. It just so happens I was only there for 24 hours, but what about the folks who have been there for weeks and they only have this 1 mask and they're the little blue mask. So they like they can wash it and use it because if you're caught without your mask on, then, you know, they take something away from you. You're already incarcerated, but then they're going to take even more, you know, and make it more punishment for you. So that's very, very hard on folks. And my phone will never stop ringing. I got people calling me from California because they have loved ones in prisons in North Carolina, and they're worried and they're concerned, and they're saying, you know, we can't talk to them, we can't see them, we don't know what's going on with them. They can't call us because they've got folks on lockback, which in lockback is mean that they're confined to their cell for 23 hours a day. And when they come out of their cell, they have to decide whether they're gonna make a phone call or they're gonna take a shower. How is that fair to anyone? Like, how can you be humane? You know, how can you be a human and treat other humans that way? We don't even treat animals that way, right? Like, I mean, it's not funny, but it is funny. My daughter was like, you know, if you want someone to get arrested, you know, if you want a white person to get arrested, do something to an animal and they're gonna get arrested. Because the police, you know, they brutalize us and beat us and nothing happens. But if they do something to a dog, a cat, a horse, they're arrested. And so if you see the difference in that, our lives are not that important to anyone but us when it comes to this system. And the system is designed to break us. It's working exactly the way it was designed to work. It's not broken. It's working the way it's supposed to. It breaks up families, it breaks up homes, it breaks up communities, and we have to stop feeding into this system. We have to look at other alternatives. As opposed to wanting your neighbor to be arrested if your neighbor did something to you, figure out why that happened, why the neighbor did that, and see what other options we can have. I learned from my homeboy Umar when his dirt bikes got stolen. The guy who stole his dirt bikes had posted him up on like OfferUp or something like that. And, you know, they were Umar's bikes, but he went to pay for his bikes a second time because he was like, he didn't want the guy in jail, but he did want to have a conversation with him because he knew that something was wrong and the reason why the guy stole his bike in the first place. So that shows me what real community looks like when you really care about people. You look at other alternatives than a jail cell.
you want to talk a little bit more about the litigation involving the prisons in North Carolina and how that's gone? Seems like it's gone back and forth and back and forth.
Yeah, I'm gonna kick that one to Leah, Brandon. I was gonna answer because she's been much closer to that. Her and my staff attorney Whitley Carpenter have been leading that work up. I wanted to comment on your question though around the impact of COVID, right? And Muffin gave a really, front lines report of what it's like for people inside. Maybe I can give a slightly different answer of like what it's like for people trying to practice right now. And so you saw my initial technical difficulties, right? So, trying to have remote hearings, right, on these really weighty, monumental issues. None of us were trained that way. I wasn't trained to do a remote hearing, right? I'm used to showing up in court and having a physical presence and things of that nature, right? So that I would lift that up as something that's really, really unique in this current day and time. Number two, just being able to get in contact with your clients. I mean, we have had such challenges in just being able to meet with our clients and being able to get evidence perfected, like affidavits signed and things of that nature. Just being able to get into these facilities to meet with your clients is nearly impossible, and it presents huge challenges in trying to move your cases forward. And then lastly, I guess number three, how this has impacted the courts and how your cases get docketed and the lag and the time that it takes to get, because there can only be so many virtual court hearings, right? And then, we're seeing, Wake County being an example, it being, different hotspot, a super spreader site during certain weeks, right? Because of the in-person foot traffic. So that all causes the administration of justice delays in moving your case forward and making that severely challenging. So I just wanted to, from a practitioner's perspective, this has also impacted us in a real way as well.
I can give just two little updates, coming off of what Daryl just said about the case itself. We filed this back in April, again, on grounds that people are being held in conditions that are cruel or unusual. The rest of us, can be outside and do our best to stay safe. Right now, there are 31,000 or so people who are packed into 51 adult prisons where they are all breathing the same air at a time where it is incredibly dangerous to do so. And as Muffin pointed out, masks need to be washed, need to be changed, and do not offer 24-hour protection against a virus that is incredibly contagious, as we all know. We won a preliminary injunction back in June where the judge in the Wake County Superior Court ordered a bunch of things, including mass testing, ongoing surveillance testing, severe limits on transfers, and lots of reporting from the state prisons on exactly what they're doing, including showing the court what their policies are. In that preliminary injunction, the court said, we think there is a likelihood that plaintiffs will succeed on their claim that the conditions in North Carolina prisons are unconstitutional, in that they are cruel or unusual. And so we have the rest of the case to litigate with that preliminary injunction in place, and we are, in the depths of discovery currently. But on Brandon's question about what are the opportunities for COVID, it is hard to see silver linings right now, and certainly in the prison context, another gentleman died over the weekend at Central Prison, 7 years old. I query why he needed to stay incarcerated. I think, it's hard to really see what the silver linings are. But North Carolina being somewhat of a, in the list of states that haven't taken advantage of this opportunity. I mean, there are other states where governors, prison commissioners, jail officials have looked at their rosters and said, who really do we really actually need to have caged in these carceral settings under these conditions? And in some states, there have been real and genuine and meaningful efforts to decarcerate. And I think the onus is on all of us as people who understand the illegitimacy of the criminal legal system, to continue to push that even after this pandemic, right? That the conversation we should all be having is, why are there so many people locked up and caged in this country? And how can we dream other alternatives up? And I know all of the students who are attending this panel have obviously been watching and been out there on the streets the same way we all have. And I think there's been a real, I think the leaders of this racial justice movement, of the racial justice movement, the long freedom struggle, have really taken advantage of this moment to push a narrative that needs to be pushed, which is that we are all connected. We need to fight the narrative that people need to be policed, arrested, and caged in the ways that they currently are in our society. And in relating to our case, that prison health, jail health, the health of our incarcerated neighbors, brothers, sisters, that's community health, right? Especially, this pandemic brings that into relief. We are all connected. If there is an outbreak in a jail that is in your community, or 10 miles from your community, or 20 miles from your community, that actually puts us all in danger. And that is something that we, should be aware of, anyway, even outside the context of these pandemics, that we are not separated, that people who are caged and hidden from our view in a system we are all somewhat silently complicit in, right? Just by living in this society, that they're not actually completely separate from us, and that we all have, an onus and a responsibility to correct our own thinking, to do our own self-work, to join this, to join in the fight, as Daryl put it, as it is led by the people who are most directly impacted, and to really shift the narrative wherever we can, because that is the opportunity of this moment. I think many movement leaders are already doing that, and if we are not on board, that is the opportunity we all need to get on board.
Thank you all so much.
So I think this is back to me to thank you all for spending time with us. I can't tell you how wonderful it is to hear about your work and your comments today, both for my practice in the immigration clinic. We are fighting to get somebody out of immigration detention. We're fighting the systemic and clear and sort of like transparent at this point incarceration of people who pose no flight risk and no danger. In a system that has become, our government as a super spreader, both internationally and nationally. And I hear your calls, and I think it's an exciting and important moment to recognize the ways that we all work together and see these movements and these connections build and grow to decarcerate, our country. So I want to thank you all, and I want to thank everybody, all our students who joined us. We hope that you will join us for the next discussion on race in the 1L curriculum focused on civil procedure. That's going to take place on Monday, November 9th at 12:30 p.m. During that, Professor Daryl Miller will convene a discussion with Suja Thomas, the Pierre and Sarah Peterson Professor of Law at the University of Illinois College of Law, and Brooke Coleman, the Associate Dean of Research and Faculty Development and Professor of Law at Seattle University School of Law. Professors Thomas and Coleman will discuss racial representation on the Civil Rules Advisory Committee, the drafters of the Rules of Civil Procedure, as well as the ways in which the Rules of Civil Procedure, such as summary judgment, which we talked a lot about today, limit the effectiveness of civil rights litigation as a remedy for discrimination. So I look forward to seeing you all at that discussion, and thank you again for our panelists for joining us today.